You're listening to Where You Live with Gene and Tony.
This is Where You Live with Gene and Tony. We're broadcasting from the Natural Green Lawn and Landscape Studios, and we're brought to you by Extreme Exteriors and by American Family Insurance, the Kim Bennett Agency. As an American Family Insurance agent, Kim believes there's much more to insurance than the policy itself. It's about providing you with dependable protection and services. Kim believes that trust and credibility can't be demanded. It can only be earned by what you say and what you do. Give Kim a call at 651-482-1598 and tell her you heard it here on Where You Live. It's time for a message from the Minnesota Multi-Housing Association. The MHA Minute is brought to you by Start to Finish Maintenance Contractors. Start to Finish provides 24-hour service for all of your home and business maintenance needs. Call Start to Finish at 952-259-1219 for your home, for your business, for your peace of mind.
Some of the benefits of successful property management. Are you ready? On-time payment of rent, improved resident quality, stabilized income, reduced turnover, controlled expenses, improved financial performance, less property wear and tear, allowance for property improvements, enhanced property value, being proactive, not reactive, better relationships with neighbors, fewer police calls, creating a community, being a great neighbor. These are some of the benefits of good property management. And whether you run a townhome association or you are renting out your condo, duplex, or 100-plus unit building, membership with the Minnesota Multi-Housing Association gives you the tools you need to run your business effectively while minimizing the headaches. Don't be a good landlord, be a great one. Visit www.mmha.com. That's two M's, mmha.com.
I want to ask our listeners to comment on the show. What do you like? What do you dislike? Call the hotline. 952-224-2668, and let us know what you think.
Well, this next article comes out of the great state of Virginia. Mm-hmm. And, a number of associations around the country have been doing this for years, and it's very typical. Some of this may not be typical here in Minnesota, but the fact that what I'm about to describe here in Virginia is the same in Florida and many other states. For years, if you're in a homeowner association in the state of Virginia, the board, the association, has been able to enforce their governing documents, and that has also included the rules and regulations. And they do that by being able to suspend non-essential privileges or by imposing a monetary sanction against a homeowner who violates one of the rules and regulations.
Monetary sanction usually means a fine.
Right? Fine, that's right.
All right.
So a small fine for $25 for not picking up after your dog.
Okay.
It could be a suspension of non-essential privileges. For example, you can't use the association's community center and pool because of some issues. And so that's quite common.
Yes, that's been a common remedy for the homeowners association.
Well, apparently now the state Supreme Court in Virginia is ruling saying that they believe that that there should be a prohibition on the association's right to impose monetary sanctions or suspension of privileges unless it is expressly stated in the association's governing documents to establish such a right. So in other words, if a specific rule of behavior is not listed specifically in the declaration or in the covenants or in the bylaws, then the association has no right, and anybody that lately who has been complaining about the association being able to enforce their rules and regulations, and they've gone to court, the Supreme Court has been slapping these down, saying, association boards, you don't have that authority.
This is very problematic, as we know, in managing homeowners associations. Governing documents are drafted and established usually by the developer of the association, or if it was let's say a rental community that converted to condos, then it would be whoever converted it, whoever took the legal steps and created this association. That's who writes the governing documents, right? And over the years, we've seen lots of variations on governing documents and a wide range of regulations and rules. The most common we see now, though, in modern documents allows the board, it says the board can create rules and regulations, and the board can create processes for enforcing the rules and regulations. I think that's a great thing, and that's an authority the board should have because things change over time. If you've got a developer establishing all the rules and regulations and the fines or sanctions that may or may not be imposed in the year 2000, those things may not apply, or they may be so burdensome by 2010 that the association can't operate the way they want to.
That's so true. A great example of that is the area of vehicles and parking. When you have an association that's 30 years old, the number of vehicles that someone had back then is different than the average household today.
Don't you remember when we started out in property management, Gene? I think the rule of thumb was 1.5 parking places per apartment.
Yes.
That's not adequate anymore, is it?
No, it's woefully
inadequate. Every adult in a household has a car these days. So even 2 parking spaces per.
Yes.
So anyway,
and so,
I digress.
But what they're doing by this, I think, is they are taking away the association's ability to act a little bit more quickly to be able to answer to concerns and issues that arise in an association. Because I agree with you, things change over time. Now, if you always have to go through the process of changing your governing documents,
which you would have to do.
Yes.
If these rules are all going to be established and the fines are all going to be established in the original governing documents, that means 10 years down the road when you realize something about the parking regulation doesn't work, you would have to go through the process of amending those governing documents, right?
Exactly.
And what is that process like?
Oh, and it's very costly. You're looking at what's considered a supermajority of homeowners generally that will have to agree to these changes and these amendments. And then after you have everybody pay for an attorney to do that, and you get that everybody voting, and you get that supermajority that say yes, now you've got to file that in the county where the property is located. Now you're talking about hundreds and thousands of dollars just to be able to do that. And to have to do that every single time you have a rule change, I think is unnecessary. To not give the association the power to have a monetary charge for a violation fee or to suspend non-essential privileges, you're taking away the teeth for the association.
Well, and you're taking away their ability to self-govern. And that's one of the attributes of a homeowners association.
It's what they expect and look
that
for.
You get to govern yourself. Now, having said that, our earlier story about the condo commando, it's that type of behavior that's forcing things like this to happen.
That's a very good point.
Yeah.
It's people that go out of bounds in the way that they handle things that cause legislatures or the judges to say, you know what? They get this idea that that's the way all associations are run, and those,
so they all have to be controlled.
And
in the
those
same
are
way.
just anecdotal.
Yeah.
They're not the way a majority of associations are run.
Now let's talk about that a little bit. So the governing documents state something, and often they say you can pass rules and regulations. Now someone gets a fine, they don't like it, they're going to court over it. It's making it all the way to the Virginia Supreme Court. And what is the court doing? Is the court interpreting the existing law and the existing contract?
No, I think that the state Supreme Court in Virginia, I think, is overstepping their authority. I think the purpose of a judge is to interpret laws that are already there, already on the books.
That's my understanding.
What they are doing
in Virginia
is they are defining things, and that's what it says here. It says that the state Supreme Court is defining the law. What they're doing is they're taking the part of the legislature.
They're not just defining, they're changing it, aren't they?
Well,
they're requiring something different than what the law requires right now.
What I meant is that they're defining they're Yes, I guess you're right. I used the wrong word there. They're more than defining the law. They are creating law.
There you go.
And,
that's
and,
what
and, so yes, that
makes sense to me.
And in that creation, they're overstepping their bounds because laws should be created by the legislature. And then if you have questions about how that is to shake out,
how they're imposed, yeah.
That interpretation is left by the Supreme Court.
Sure.
And I think they've overstepped their bounds here, and I think they're taking away some of the fundamental rights of ownership of a property.
They absolutely are.
Because here you have a homeowner association made up of 100 people. They own that property.
Mm-hmm.
Do they not have the right to run that association in that manner if they feel that is how they think things should be done?
That's what their documents say right now.
Yes.
But the Supreme Court
they
is
have a different
changing the
idea,
rules.
don't they?
Yeah.
Well, boy, there's so much more we could say, but we've run out of time. Folks, thanks for joining us. We hope you have a great weekend. We look forward to having you here next Saturday, right here on Where You Live with Gene and Tony.
Well, goodbye.
Tough to say goodbye.
Bye-bye, everybody.
Take care now. Bye-bye then.